We're live.
Good afternoon. It is the afternoon of March the 18th, 2022, and this is the House Judiciary Committee. We have a number of bills we're going to hear in a voting session today, and we're going to start with House Bill 104. House Bill 104 is Chair Atterbury's bill on child custody. If you go back in time, there was a conversation related to the second part of the bill where there was some controversy about the second part of the bill as opposed to the first part of the bill. There is an amendment that would take out lines 19 through 33, which is the second part of the bill, that basically says any reasonable effort to protect a child or a party to a custody or visitation order from the other party may not be considered an unjustifiable denial of or interference with visitation granted by a custody or visitation order. My memory of the hearing was that there was concern about that. The sponsor, with an eye towards keeping at least this bill moving, was willing to strike that and move the rest of the bill.
Move the amendment.
There's a motion for the amendment. Is there a second?
Second.
Right. We're on discussion to remove lines 19 through 33 of the bill. Is there any discussion? Delegate Shoemaker.
Thank you, Mr. Chairman. Could you recap for us or somebody?
Lauren, do you want to tell us what the bill does anyway?
Sure. So as amended, the bill basically clarifies language in a statute relating to the considerations a court is required to make in determining custody and visitation when a party has committed child abuse or neglect. So it requires the court to state with specificity its findings, and it requires a court that approves a supervised visitation arrangement to specifically take into account the type of child abuse, including whether the abuse was emotional, physical, or sexual.
Okay. So the language that we're taking out through this amendment that resulted from concerns expressed by the judiciary, as I recall, is that right?
That's correct.
Okay. Thank you.
Delegate Arikan.
Am I the only one that's uncomfortable removing that bit? I mean, I'm just looking at it and it's important. I mean, it's a huge protection for protective parents who, get information, on a weekend or a time when it's impossible for them to make a legal change of plans for a child. This piece prevents them from being penalized. And this happens. This is happening. Mothers are having information disclosed to them. People I know have had information disclosed to them on a weekend, have called their attorney's offices. Especially during COVID, it was hard to get in to the court system. And so they had to make the decision. And I have had to watch mothers send their children back to the homes where their children have said that they're being molested.
So let me say this. I mean, we have passed this bill in the past as the sponsor introduced it. I was trying to reflect some of the comments that were made by some of the witnesses on I think on almost every side of the issue concerning the second part. But look, I mean, the amendment's before us. The amendment would strike that. And I'm now just, let's have some discussion and see what people think. I'm not going to.
Did the Senate strike this?
I don't think the Senate's done anything to it.
Okay. I mean, if we were conforming to Senate so we could move.
I got it.
Top half, I would be all
Sure.
for it. But if we want to just present our, the House's best version of the bill, I would really prefer to keep that part. And I think it's important.
All right, let's hear from others. Delegate McComas, then the vice chair. You're muted, Delegate McComas.
Thank you, Mr. Chair. I guess what I'm kind of concerned about is I went back and listened and read the testimony of the judiciary, and I guess what I'm a little concerned about is are we changing the standard? Because in other words, it had to be, I believe, clear and convincing that there was interference, and now we're changing it a preponderance of the evidence. And so we're lessening the standard significantly, and it goes from an objective standard to more of a subjective standard. So if the guy thinks that they're that what's going on is a concern one way or the other, they can deny the visitation. And they talk about, which I know, custody cases can be more contentious and more subject to lying, prevarication, and outright deception in custody cases than in a murder case. So I guess I'm a little kind of concerned if we're changing the standard, and whether, I guess I'm kind of concerned. And there was a significant amount of unfavorables when this bill initially went in. So if Lauren could kind of.
Lauren, can you talk about the shifting of the standard? Are we shifting the
Yes.
standard? Because I see the preponderance standard, but I didn't see clear and convincing.
Right, that's not so much the standard that they're concerned about. It's the standard from unjustifiable denial or interference, which is found in the current law on page 2 of the bill, line 21. That's being changed to a reasonable effort to protect a child. So the argument of the opposition to that piece of the bill is that that standard is being changed from what's an objective standard to a subjective standard.
But that has to do, and that issue has to do with what I've called the second part of the bill. So where we are right now, the amendment would remove that part of the bill, correct?
That's right. So the amendment would remove lines. Well, it's going to strike that whole section of law starting on page 19. I'm sorry, starting in line 19 on page 2, just removes 9-105 from the bill, which just restores it to its current position. It does not, so in essence, lines 30 through 33, the new language,
Right.
not become law if this were passed.
But just to be clear, we're not striking 9105 as it currently stands.
That's right. We're not
by
removing
doing
it
this.
from the law, just
the part that was being added.
correct.
Okay. All right. The vice chair.
So I obviously voted for this bill in full last time with everybody else. And so my interest in the amendment has been from a practical perspective. And so I guess my only question is whether we have reason to believe the bill as introduced, did it run out of time in prior sessions, or did it actually get a look and isn't likely to move in that posture? If it's a fresh question for the Senate, then I guess I'd be more open to doing it as introduced. But if we have evidence that, hitting the end of the deadline period here, that, we need to get something over and they do have problems with it as introduced, then I would press the amendment.
I don't know the answer to that question, and I'm sorry to say, I just don't know the answer to the question. I was reflecting more on the testimony that we heard as opposed to what the Senate may or may not do. I'll just tell you.
And has the sponsor weighed in this concern?
I spoke to the sponsor last night. She pointed out that we had passed the bill clean last year. She, I believe, would be happy to have something moving, at least at this point. But I'll just be clear. I think she said we passed it, we passed it in the way it was introduced last year. So
was it cross-filed?
I think there's a cross file. Yeah, there's a cross file in here.
I mean,
Senator
and
Lee's,
they've,
they haven't
okay.
done anything to Senate Bill 41. Am I correct about that, Lauren?
Yes, there's a cross file.
Cross file.
And was there a crossfile last year? So they had the hearing last time also and didn't take action?
It says, I'm looking in the fiscal note, I have to look a little bit closer, but it looks like Senate Bill 57 of 2021 as amended passed the Senate and was referred to House rules. No further action was taken. So I can spend a minute looking up. I don't know what condition it was when it passed out of there.
So they passed something on
They
this,
passed something.
huh? Well, now I hate to say, now I'm a little more curious.
All right, well, let's do this. We have a couple more people with questions, and that might give Lauren a half a second to figure out how they passed it out of the Senate.
Yes, I'll do
Delegate,
that right
all right, Delegate Carden. Hopefully
Thank you,
we've
Mr.
got a question for Lauren.
Mr. Chair, just a real quick question, maybe you know the answer to this. The part that we are talking about striking from the bill, is that the part that the opposition, that all the opposition had opposition to? And can you just tell us who that opposition was? Because I believe it was like the Women's Law Center and the Sexual Assault Association and
There were two people who came in favorable with amendments. They were Michelle Smith from the State Bar, from the Family Law Bar, Lori Ruth from the Women's Law Center. They were favorable with amendments, and the amendment was to strike
that part of the bill.
105B. There were two people completely unfavorable. One was Eric Smith from Winning Strategies. The other was Vince McAvoy.
Thank you.
Looking at and the written testimony, favorable with amendments, Lisa Jordan, Dorothy Lennox, Melanie Shapiro. As has been pointed out, the judiciary was completely opposed. And Karen Merwin from the Boys Initiative was completely opposed.
Okay, thank you.
Delegate Crutchfield.
Thank you, Mr. Chair. I just wanted to add a comment on to Delegate Parton's question. And that is that I've been contacted by a couple of the advocates who have indicated that they would like the bill to have this amendment attached to it. So, and they were several of those groups that you had mentioned earlier, Mr. Chair.
Delegate McComas.
Thank you, Mr. Chair. I was looking at the bill, okay, and it says, okay, on page 2, which we're not taking out, it said, it goes, except as provided in subsection B, a party, if the court finds by a preponderance of the evidence that the child has been abused or neglected by the party, unless the court specifically finds that there is no likelihood of further child abuse or neglect by the party, so that there can be visitation. But the thing is, the no likelihood, I mean, I just can't see a court really wanting to stick their neck out, with those other provisions. And it is a low bar, being preponderance of the evidence, as opposed to the, whatever the prior standard was. Except that the court may approve a supervised visitation that assures the safety, physiological, and psychological well-being of the child. Well, that's gone. So I don't know. I'd like to see what passed out last year, and maybe see what the Senate comes up with.
Let's do this.
Oh, it does say
I'm
assure. Okay, it does assure on 2 the.
Here's what I'm going to do. I'm going to pause House Bill 104 and go to a bill that is not Lauren's, so that she has the opportunity to tell us what the Senate did. And so we'll keep moving here, and then give Lauren a chance.
I'm okay. I can tell if that's
okay.
helpful. I found out that the Senate, just to that one question of Delegate Moon's, the Senate the bill that came over from the Senate last year that got into rules did have the provision that is being discussed, lines 30 through 33, as did the House bill. So both passed with that provision in it.
Well, then I would move the previous question.
So I'm sorry.
So the Senate bill that passed over here from last year, Senate Bill 57 of 2021, did contain the provision in lines 30 through 33 about any reasonable effort to protect a child from the other party may not be considered an unjustifiable denial.
Okay, so they passed it in the form in which it was introduced in the House.
Well, there were a bunch of amendments on both sides. Like there were other provisions of the bill that had to be adjusted to get to to make a long story short, the bills were introduced with other provisions in both that that are not at issue here. So, but basically these provisions are what was agreed on by both houses last year. What you see in front of you are the two bills that passed out of both houses last year.
All right, I suspect that there will be more to this story. So right now, there is an amendment to remove that second part. What I'm going to do is let's just vote on whether to remove the second part or not. If we don't remove the second part, fine, we'll just move on the bill and get on with it. And we'll see where people are. And we'll get going. Delegate Bartlett, you raised your hand. Delegate Erican had raised your question. Delegate Bartlett.
Okay, so I just want to make sure, so we are going to not consider section 9-105. That's what you're saying?
This amendment would remove
Yeah, 9-105.
effectively from the bill, not from the
Right.
law and Tyler, just from the bill.
Right.
So if you want to do that, we can pass the amendment. What we just learned is that the Senate passed legislation
With 9, yeah.
with that there. So that's where we are.
And they passed it with all of 9-105 and not about all of it, but all that is in this bill.
But the part
And-
that's in this bill, yes,
Yeah, and B, they also, the new language for B, they passed it.
that's what we're saying, yes.
But we're saying we're gonna take it out of this bill.
We're saying that people can decide what they want to decide. We can either take it out and move it without it, or we can leave it in and send it to the Senate, and then we'll go from there.
Okay.
All right, Delegate
And then,
Eric.
sorry. Oh.
Yeah, we need to, yeah.
Sorry. So for those of us who want to pass it in the same form the Senate passed last year and who do want that.
You would
piece
vote
in,
no.
We would vote no against.
You'd
the
vote
amendment.
no on the amendment,
Okay.
correct. I'm not going to do a roll call. I'm just going to do people raising hands. The vice chair, I think, is moving the previous question.
Well, no, sorry. I just want to clarify this last bit you throw on here. The advocates want us to pass the amendment.
The advocates want us to pass the amendment.
The
Senate
Senate
passed
passed it
it.
without the amendment.
Correct.
Well, this is weird. Okay.
One way or the other, a vehicle will move, and we're going to move this along and go from there. All right, so this will be interesting, I guess. All those in favor of the amendment, please raise your hands, and when I call your name, please lower your hands. If you're in favor of the amendment to remove, I see delegates Cardin, Grammer, Howell, Crutchfield, Shetty, Williams, Tolles, Moon, Davis. I count 9. All those who are, and I'm sorry. So again, these are votes. Delegate Lopez and Erican, just raised your hands. Are Delegate Lopez and Erican, are you voting for the amendment or against? Lopez is for, so that's 10. Jones is for, Bartlett is for, that's 12. All those against the amendment, please raise your hands.
This is so that it's the Senate version. The
So that
passed.
would be, so it's a Senate version. Cox, Erican, Shoemaker, McComas. I think I saw Kurt waving on to be a yes, not a no. That's right. Okay. So the amendment is adopted, striking that section. So now we're on the bill as amended, striking that section.
Move favorable.
There's a favorable with amendment.
Second.
second. Any further discussion? I feel like we've done this enough. All right, we're gonna do a roll call. The vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett. On the bill.
Yes, yes, sorry, I had so many amendments
Okay.
open.
Carden,
Yes.
Conaway is excused. Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Wanika Fisher,
Yes.
Grammer, Grammer,
I'm sorry, yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas.
No.
Okay. Munoz is excused. Shetty,
Yes.
Cham. She's still ill.
Yes, she is.
She's still, yeah, that's right. Tolles,
Yes.
Williams,
Yes.
6, 9, 13, 16-2 with 3 excused. All right. Now we're going to House Bill 244. There are no amendments. Vice Chair, would you like to say what the bill does?
It prohibits the reduction of a damages award on the basis of race, gender, et cetera. And this is basically about young people or children who have no wage history when there's an injury and liability is determined, and you need to figure out how to calculate their lost wages. So that's the bill in a nutshell.
Delegate Fisher.
I had a question for Vice Chair Moon.
Well, let's do this. Let's get a motion first and then I'll do that. I should have done that right. So could I have a motion, please?
Move favorable.
Favorable for the second?
Second.
All right, fine. All right, now Delegate Fisher, go ahead.
I saw that Delegate Buckle is a co-sponsor. Is that true?
That is correct.
Okay.
That's an interesting question. One for the ages. Are there other questions? Okay, Delegate Cox.
Thanks, Mr. Chair. I would like the honor of being added to the bill as a co-sponsor, if the chair would entertain that.
We don't have amendments on the bill. So what we said was if there are amendments that we're already putting on the bill, we would accept sponsor amendments. There's no other amendment. We already moved favorable. There's not amendments on the bill. So with respect, Delegate Cox, I apologize. Again, Debbie Downer, add it to the stack. All right. Seeing none, seeing no further comments, we'll take a roll call. The Vice Chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Definitely, yes.
Carden,
Yes.
Conaway is excused. Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Wanika Fisher,
Yes.
Grammer,
No.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas.
I guess I can't ask a question. Can I? There,
No.
well, there was some issues with Maryland State Bar had favorable with amendments. Some other folks did. I'll say Alpaca, Robert Inton, favorable with amendments. And I'm just wondering if there were no amendments, that means that none of these were put in.
That's right.
Deductive reasoning.
Yeah, and then,
Be
okay,
nice to Delegate McComas, but Delegate McComas, I'm going to need you to cast a vote.
I'm gonna vote no, because if there was no amendments, because a significant group wanted amendments, so.
I understand. Delegate Shetty,
Yes.
Delegate Tolles,
Yes.
Williams.
Yes.
All right, 15-3 with 3 excused. We're going to go now to House Bill 521, which is Delegate Pena Melnick's bill. This legislation, I believe as amended, and Holly can correct me, there is a reprint in your packet, 643620. The amended version would, as I understand it, would only have to do with records that are a result of something being filed during the COVID pandemic. Is that correct, Holly?
So the bill was already drafted to just be during the COVID-19 pandemic. The amendments do a few other things, and I can talk about those if you'd like.
Sure, go ahead.
Okay, so the bill authorizes the tenant to petition the court to shield during the COVID-19 pandemic. The amendments provide that the provisions do not apply to a record relating to an action for repossession that results in a money judgment entered in favor of the landlord, except under very certain circumstances. The amendments also prohibit a petition from being filed until the appeal period has lapsed. And the last amendment alters language in the bill, providing that the court may instead of shall grant the petition. But if the court denies the petition, the court must provide the reasons for the denial. And that's
Move the amendment.
All right, there's a motion for the amendment. Is there a second?
Second.
Second.
Okay, second. Now we'll have discussion on the amendment, please. Delegate Cox.
Thank you, Mr. Chair. Is it possible that this has resolved any of the issues presented? In other words, I think some of the entities that came in concerned, is that why this amendment is that resolving all of those issues, or are there still outstanding objections?
All right. Are there further questions or comments on the amendment?
Did anybody hear me?
I did not hear you. I'm sorry. Say that again.
Oh, okay. I'm sorry. I'm wondering if this amendment resolved any of the concerns brought forth by some of the advocates in opposition.
I don't have an answer to that question. I think that the idea was that I know that Delegate Pena Melnick did work with the advocates to narrow down some of their concerns, and it makes this a very a pretty different bill. Holly, do you have any insight on that?
I can just offer, I know that the may to shall, the last amendment that I spoke about, was the big concern that the court shall grant all the petitions. And it seemed that by changing it to may and give the court an out, it seemed to satisfy some of those concerns.
Okay. Delegate Cox?
Thank you.
All right. We have a motion and a second on the amendment. All in favor of the amendment, please raise your hands. Delegates Bartlett, Jones, Grammer, Howell, Shoemaker, McComas, Lopez, Williams, Anderson, Shetty, Crutchfield, Fisher, Moon, Davis, Tolles, and Cox. Anybody opposed to the amendment? Seeing none, the amendment's adopted. We're on the bill as amended.
I'm not opposed to the amendment. I'm sorry.
Are you opposed to the
Oh,
amendment?
no.
Oh, no, I didn't say you were opposed to the
Oh,
amendment.
I'm sorry. I thought
You
you
were
said
in
my
favor of the
name.
amendment.
I'm sorry.
All right.
Move as amended.
Okay, so
Move as amended, Mr. Chair.
thank you very much. Is there a second?
Second.
Thank you very much. Any further discussion? All right, go to a roll call. The vice chair.
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
No.
Bartlett,
Yes.
Hardin,
Yes.
Conway excused, Cox,
No.
Yeah.
Crutchfield,
Yes.
Davis,
Yes.
Fisher,
Yes.
Grammer. Robin. Okay. I heard no. Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas,
no,
Munoz is excused. Shetty,
Yes.
Sham is excused. Tolles,
Yes.
Williams,
Yes.
see 13-5. That's favorable with amendments. It'll be going to the floor. I'm going to skip forward here to 1021, a bill that we spoke about before. It's the speaker's bill. And Delegate Erican, are you just being first out of the gate to ask a question, or are you, okay, that's fine. That we'll get to you in a moment. There are amendments. There has been a reprint of the bill that's been sent to everybody. It's a little different than what was sent out this morning in that there was some clarification on the language regarding the sort of tiered nature of this, where it's a first, second, and third offense. The third offense would be revocation. Second offense would be suspension. But one of the questions that came up in the discussions was whether or not people had a hearing before they were determined to have had a second or third offense, and the answer is yes. They're supposed to have a hearing with that. The Speaker's office has worked with on the amendments, worked with people from the firearms industry, from the firearms dealers. And it's my understanding that they are okay with the bill. Others will tell me if I'm completely wrong or not, but that's certainly my understanding. And with that, could I have a motion on the amendments, please?
Move the amendment.
All right,
Second.
second. All right, we're on the amendments, which effectively is going to be the bill anyway. So now we'll take Delegate Erican.
Thank you, Mr. Chair. So I talked to DLS a little bit about this, and they did tell me that this didn't include like FFLs who don't have a retail location, but when I'm reading it, it says a licensed dealer may not conduct business and store firearms at a location unless. That seems to include everyone. So is DLS just wrong in their reading of this? Do they not understand that this essentially prohibits people, which most FFLs don't have retail locations. They buy and sell small amounts of firearms, maybe 20, 25, 30, 50 a year. They don't have a retail store. They just, have 2 or 3 stored at their home.
But this is not necessarily an FFL. This is a dealer's license. This is using the state law and not a federal firearms license. There's a distinction, I think, between the two, at least in the way that we deal with it.
Okay. So
wait, did I maybe get something right on a gun thing and actually convince Delegate Erican? Because
I don't know. I guess if maybe Claire could tell us what the definition of a licensed dealer is, because it's not.
It's actually Holly. It's actually Holly.
Sorry, Holly.
Well, that's all right. And I'm going to pull the public safety article at the same time.
Yeah, I'm pulling it right now too.
Because we actually had this discussion as part of the discussion on the bill when I was going back and forth with one of them, Mr. Pennack, I think, and I was pointing out that we were talking about the dealers and that's distinct.
Yeah, okay, that's right. That was a confusing piece because I think the federal term is like licensed firearm dealer, but our term is licensed dealer, which is
it's a little different.
Right.
Yeah, we do a dealer's license, and this is dealing with the dealer's license, and that I believe lives 5106. Our bill applies to any FFL where they conduct business, a premise.
Yeah.
What I have is Maryland law requires an additional dealer's license for FFLs. So an FFL is distinct from that.
But all FFLs have to have a dealer's license in Maryland.
I believe that's correct.
So this should then include literally everyone, even people that sell from their home. So then they would
Holly,
not be able to sell from their home anymore, which is what most of them do.
a dealer's license is required for each place of business where regulated firearms are sold. So Delegate, you are right. I guess I could double check. I mean, who did you speak with in DLS?
It was Colleen. I have my chief of staff call over. I can try and see who she spoke to, but
I can just ask clarity on where they got their information, and then I can look into it right now and just see. But
and that's fine. Why don't you do that, and we'll
Okay.
come back and we'll be clear about who we're talking about and who we're not. That's fine. But we'll let you do that, and we'll go to one of Claire's bills. Then we'll go to House Bill 863. That's Delegate Terrasa's bill. Delegate Terrasa, the Office of the Public Defender, and the State's Attorneys Association. The problems have apparently been addressed, where there is an amendment that apparently addresses the state's attorney's concerns and is something that OPD can live with. So the amendment is 253723 on House Bill 863. And I'll take a motion on the
I'll
amendment.
move the amendment.
Motion for the
Second.
amendment is second. Is there discussion on the amendment for House Bill 863? Seeing none, all in favor of the amendment, please.
Mr.
Yeah,
Mr. Chair,
Delegate Bartlett.
is there a page 1 to the amendment, or does it just start at page 2?
There is a page 1 that says at 9.120.1 A1, in this section, the following words have the meanings indicated. Forensic laboratory has the meaning stated in 17.2A01 of the Health General article. And then it goes to page 2, physical evidence has the meaning stated in 17.2A01 of the Health General article. So it basically says that a forensic lab is under the health, they're using the definition under the Health General article.
Okay, thank you.
There are no other questions about the amendment. All in favor of the amendment, please raise your hands. Delegates Bartlett, Jones, McComas, Cardin, Lopez, Shoemaker, Howell, Williams, Fisher, Crutchfield, Shetty, Anderson, Tolles, Davis, Grammer, and Moon. Anybody opposed to the amendment? Seeing none, the amendment is adopted. We're on the bill as
Move
amended.
favorable.
There's a motion for a favorable as amended. Is there a second?
Second.
All right, questions? Delegate Fisher?
Hi, Mr. Chair. I just have a little clarifying question. So this bill is just trying to not have the requirement of a letter for a forensic, when you're in a criminal proceeding, that you don't need to say that you handled the data or physical evidence. Like, I'm a little confused on what it's doing.
It goes to a question as to whether or not people are able to question the results of a state forensic lab.
Right.
It goes to the back and forth between the Office of the Public Defender and the state's attorneys who are handling the case.
And what did the public defender say?
The public defender was in favor of the bill as it came in. The state's attorneys were opposed to the bill as it came in. They have since had conversations with Delegate Terrasa and have both come to this language, which they're both okay with.
Okay. And
That addresses-
what problem is it trying to solve? I'm sorry, Mr. Chair.
I mean,
I usually can follow along, but this one I'm a little.
it is one of the more esoteric. Here comes the vice chair though, and maybe he can help.
Yeah, just tell me what they're trying to fix. That would be helpful.
There's a provision in law that requires expert testimony of this type of lab analysis to be done by a professional qualified by letter from the Department of Health. And the reason for that requirement is that if you're handling specimens, they want to make sure you're up to snuff with Maryland's specific training and certification or whatever, the state requirements on this. And so experts were being denied on the basis of not having this letter. And the question came in, if you're not handling the evidence directly and you're merely commenting on the analysis of the state folks, the people who are coming through this process, can you testify in court? And where the amendment gets us, I think the bill said, yes, you can. and the amendment, if you're not handling the materials. And where the amendment gets us, it says it's up to the judge to qualify the witness as they ordinarily would, and the letter is not needed in specific if you're not actually handling the results. And so everybody's happy with that result.
Okay, Moon, you sure you're not a trial attorney? That was good. I got it.
He's getting there. Delegate Cardin.
Thank you, Mr. Chair. So usually there's like a chain of custody issue. I guess in here, there wouldn't be a chain, this wouldn't be it would be that you would qualify the witness on whether what they're testifying to is appropriate based on their expertise. And so basically you're giving the judge, Delegate Moon, you're giving the judge the ability to decide whether they can testify based on their expertise and their observations of whatever it was without ever having been part of the chain of custody. Would that be fair to say?
Correct.
Okay.
Okay.
I can't understand why the prosecutors would be opposed to that. But
Well, move favorable as amended.
All right, we're moving favorable as amended now.
Second.
Great. Any further discussion? Seeing none, the vice chair.
One
Yes.
quick question.
Okay, sorry, Delegate Bartlett.
I'll be really quick. I forgot which attorney's bill this is, because I have a question about the language in the bill. I'll tell you what, I'll ask my question. I'm not sure which counsel is handling it, but why on page 2? Why do we go on page 1, forensic laboratory has the meaning of the health article, and I know that's what you were talking about, Chair. But why do we go over it again and say it includes this and then it doesn't include this? That's just something to make it really clear. Is that why we're doing that? That's not new language. I just was
No.
wondering why the new
Claire.
language needs the health article.
Claire, do you have any insight?
Well, that's not really a part of the bill anymore. The amendment is relocating the operative language of the bill from the health general article to the courts and judicial proceedings article. I believe there's a reprint if you go beyond the actual amendment in the packet, the next.
Is it because that's in 17-2A-01? That starts a new section?
Yeah, so
I think
it's
so.
relocating the language and saying that instead of the Secretary of Health may not require this letter, a court may not require this letter.
I got you. Thank you. Thank you.
The rest of the stuff is just not really changed.
Right.
Except
The
they're
vice chair voted
data.
yes. Delegate Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Now,
Bartlett,
Yes.
Cardin,
yes,
Conaway is excused. Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Shetty,
yes,
Sham is excused. I saw that. Tolles,
Yes.
Williams.
Yes.
All right, see 16-2. All right, we're still getting answers on the speaker's bill, so we'll come back to that in a second, as long as it's still over here, which it is. Oh my, Delegate McComas. 1169, we've passed this bill each of the last 2 years.
Move
We're back
favorable.
again. There's
Move by
no-
favorable.
No, we're gonna move it favorable.
Second.
Second on the favorable. Any questions on Delegate McComas's bill that we have passed? Just looking at the fiscal note in 2020, we didn't pass it, but we did pass it in 2021. We're gonna try again. Any questions about it? Don't see any questions about it. Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
No.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas.
Yes,
Are you sure?
Yes.
Shetty,
third time's the charm, we hope.
Shetty,
Yes.
Coles.
Yes.
Actually, I should have asked Delegate McComas if I had a quick question. Never mind. Delegate Williams,
Yes.
17-1. All right. All right, we're done with that one. We're down to two. One is the speaker's bill. The other is something that the vice chair has been working on. So we're going to go ahead and deal with the bill that the vice chair has been working on. And this is House Bill 1298. Delegate Christ. It is an expungement bill.
Oh,
everyone.
goody, an
An
expungement.
expungement bill.
Yeah,
Mr.
he
Vice
would do it.
Chair, Mr. Vice Chair, what does this bill do?
So the bill as introduced sought to take all of the crimes in the fishing article and all of the crimes in the hunting article and make them eligible for expungement in a 3, 5, or 10-year window. So I took a look through the code, and so there's an amendment. Long story short, there's an amendment. So let me
There's an
move.
amendment for what
Let me
it's
move
worth.
it.
All right, is there a second on the amendment?
Second.
All right, great. All right, now we'll
So-
talk about the amendment.
Okay, so the amendment deletes the bill and starts over, trying to, instead of taking whole titles and trying to make them eligible, to find some things that seemed like an easy lift. It's actually this is a very complicated section of law to try and expunge, because there's a whole range of stuff in there. So what I did was I picked out some things that seemed consensus based. In the hunting article only, I completely deleted the fishing article because I learned through this process that fishing, and only fishing, has its own expungement process within the natural resources article. And I just need to understand more about why that is and what that means. So we dealt with hunting here. And these are the offenses that are going to be in for expungement. They're all essentially license violations. Hunting without the right license, those are all just fines on your first offense. This includes hunting license needed for game, bird, or mammals, possession of that license, stamps for hunting migratory birds, a non-resident trapping license, a falconry license, a retriever dog license, license needed to hunt from a blind. And then the only non-license offense in here is that you didn't wear the proper attire, which has to be bright, orange or pink or neon, I forget. So those are the offenses. The bill is introduced also sought to put in different timelines. I just left, again, it's too complicated to do like this willy-nilly. So I left it's a 10-year waiting period still, and we can deal with more things later, but that's the bill for now.
Keeping in mind, we do still have to get to the speaker's bill next. Delegate Fisher for a question, then Williams, then Cardin. Wow, then Delegate Fisher went away.
Sorry, am I still here?
You're still there. Do you have a question?
Yes, thank you, Delegate Moon, for all your hard work. I'm always impressed by you. My question is, when you say it's the 10-year wait period, you mean it's they have to wait 10 years to get the expungement, or what are you saying with that?
Yeah, so there's an existing list of offenses that are eligible for expungement. but it's 10 years after you finished all of your conditions, whatever. And so this is just adding these specific hunting offenses in as eligible for expungement and not changing the timeline at all.
Got it. Okay.
I flag it only because the bill was trying to bring in this 3, 5, 10 tiered system of how quickly you could get these things expunged. And there's merit to that for some of it. We just can't, we don't have time for that right now.
Delegate Williams, then Cardin, then Anderson. Delegate Williams.
I think I've inadvertently answered my own question by going to the natural resources article. God help me. So this doesn't, so it looks like it's very specific. It doesn't touch the non-game endangered species part of the code, it looks like, or any permits or hunting as it relates to the endangered species part of the article then.
Let me clarify. The DNR police and the Humane Society are cool with this amendment.
Okay,
We're not
all
going
right. I
to
think
let
I'm
you-
okay now.
We're not going to let you expunge killing an endangered species.
Okay, because that was my concern that I had initially with
That
the bill,
would
so.
be bad. Delegate Cardin, then Anderson.
Just real quick, thank you. If I had like a violation in year 1 and then another violation year 2, and then you get another violation year 3, do they all qualify at 10 years and then 11 years and then 12 years to get expunged after I've finished my term? Or is this only for a first time offense, second time offense, or how's it work?
I think if they happened in that sequence, you might be able to do it, but the one in the middle might get botched because I think it breaks the chain. Sorry, this is my dog is yelling. If you have a subsequent offense as your expungement period is tolling, you won't be able to do it. So the first one and maybe if that makes, does that make sense?
Yep. Yeah. Okay, that makes sense. Thanks.
Delegate Kurt Anderson.
Yeah, thanks. Thank you, Mr. Chairman. Delegate Moon, the offenses that you picked, do they have jail time associated with them or just fines?
I think some of them in that article might after multiple offenses, but generally I think a lot of them are $1,500 fine first offense, some of them are $500 fine. They're all fine stuff. And again, this is a 10-year waiting period on you didn't pay for the proper stamp or license when you were hunting. The hunting itself was legal.
So my question is, these don't seem like very serious offenses. Why should the person have to wait 10 years?
I agree with you. I just think it was too much. The bill came in with 2 whole titles, and it was too much to try and sort out separately the waiting periods and make them consistent with some of the other offenses in there, which, frankly, if we're going to change it on this, I would change it on a whole bunch of other stuff too. I don't think we want to be just doing this without considering whether the other offenses are being treated in the same manner.
Was there a Senate cross file?
Yeah, this is Senator Bailey's bill, I believe.
Okay, did he have similar amendments or what?
No, this is very like, okay, if there's, an extra hair of time, try to squeak one more bill under the wire.
I would vote for, and you're probably not proposing it, but I'd vote for reducing the time period from 10 to 3, regardless of the nature of the offenses, because all of these are non-jailable. And it's like
while I agree with you, I hesitate to do it because there are not only has this been signed off on, but there are multiple offenses like permanent. You can have a permanent suspension of your license, and then you go to fish anyway or hunt anyway, and then it becomes jailable on some of them. So again, I don't want to do it without giving a longer look at how we do this. But again, I agree with you generally.
We're on the
bill
amendment
for next year.
We were on the amendment. It was seconded. All in favor of the amendment, please raise your hands. Delegates McComas, Cardin, Howell, Williams, Bartlett, Shoemaker, Lopez, Anderson, Crutchfield, Tolles, Moon, Fisher, Shetty, Davis, Grammer. Anybody opposed to the amendment? Nobody's opposed. Any further? Can I have a motion on the bill?
Move favorable as
And
amended.
second.
Can we pile on, Mr. Chair, or not? There's an amendment on the bill.
Yeah.
No.
Luke says no. Let's go.
Let's get on. We need to get on with it here a little bit. I don't see any further comments. The vice chair,
Yes.
Shoemaker.
Surprisingly, yes.
That's one Republican for an expenditure bill. Anderson.
Joe Valerio would have let us pile on.
It's been 4 years now, Kurt. I mean,
Oh, I
really,
thought it
I'm
was-
sorry. I can't help you there.
I thought I was on mute. I'm sorry. Yes.
And Erican.
No.
Oh, what? Bartlett.
Those are your people.
Going
Bartlett.
with Shoemaker on this one. What? Yes.
Carden.
Yes.
Cox.
Yes.
Oh, Crutchfield.
Yes.
Davis.
Yes.
Fisher.
Yes, I love my chair.
Oh, Grammer.
Yes.
Howell.
Yes.
Jones.
Yes.
Lopez.
Yeah.
McComas.
Yes.
Shetty.
Yes.
Tolles.
Yes.
Williams.
Yes.
17. Now we're back to 1021 where I think we have answers now, hopefully.
We
Holly,
do.
what did you learn?
So I talked to Colleen, Delegate Erican, and I found out that your amendment that you wanted would have exempted non-retail dealers that sell out of their primary residence. So I spoke to John, and so under Public Safety 101D, dealer means a person who's engaged in the business of selling, renting, transferring firearms at wholesale or retail. That's why he said you didn't need the amendment, which is correct. You don't need it. Now, if you're worried about the smaller retail dealers that might operate out of their home, that is why all sides came to the table. And if you look at page 2, Roman numeral 4, that and became an or, so that if it is a smaller establishment outside business hours, that licensed dealer just has to lock all the firearms in a vault, a safe, or Roman numeral 3 under paragraph 2 circles back to A, where they could have all of the requirements under A and satisfy it as well. I hope that helps.
Okay, so is this the right page? I feel like I'm confused about the page.
Page 2.
Of the reprint, Holly?
Yeah, of the reprint. Sorry, yes, of the reprint that went in your vote packet. Page 2, Roman numeral 4, it starts with if practicable physical barriers. And then if you see the and has been scratched out and has been struck from the bill, and now it's an or. So for the smaller dealers, they would just have to then satisfy 2.
Okay, and they already obviously.
Yeah, I think that was the thought, especially if it's their home, that would
Right.
already be satisfied.
It's likely that it would be, although I kind of want to like at least touch base with them and see. I mean,
But then just back to Public Safety 101D, it would be the other definition that you were looking for. So
We've had a look, and I understand your hesitance there, Delegate Erican. You've worked on these issues before. I think that I'm inclined to move forward here. We had previously, I believe, a motion on the amendments that you've got before you in the interlineated version of the bill, just to make sure. Could I have a second on that? On
Second.
those amendments? That's fine. So we are now on the amendments for 1021 as they're before you. All in favor of the amendments, please raise your hands. Bartlett, Carden, McComas, Lopez, Shoemaker, Erican, Howell, Williams, Moon, Tolles, Cox, Crutchfield, Anderson, Shetty, Fisher, Davis. Anybody opposed to those amendments? All right, Delegate Tolles' hands is still up, but that's all right.
Move
All right.
favorable.
There's a motion for a favorable. The
Second.
bill is amended as a second. Is there any further discussion? Seeing none. The vice chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
No.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Fisher,
Yes.
Grammer,
No.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas,
No,
Shetty,
Yes.
Cham is not here. Tolles,
Yes.
clarified, Cham is excused. Williams,
Yes.
13-5. All right, that concludes what we have on our vote list for today. We may be back again. I'm sure we will be. But that concludes the vote session for today, the 18th of March. We thank you all very much for watching, and the floor begins at 5 o'clock. Thank
And
you.
we're not
very
going to
much.
be, we're not coming back today though, right?
I don't believe we are coming back today, but please listen to the floor just in case. All right,
It's
thank
cold
you.
out here.